For staying with us. This is Law School Made Easy at Law School Made Easy 256. Please subscribe, share, and like our videos. Today we are going to look at the principle of legality, and we have a Latin marxism to mean the principle of legality, which is nollam poena sine lege. That literally means that no punishment without a clear description in the law. There shall be no punishment. Nobody shall be punished when there is no law governing that. Basically, that is the principle of legality. This principle, one of the most important things about it, it is protecting. It is protecting, one, the people, and two, the offenders. That much as somebody has offended, there must be standards how those people should be handled, how they should be taken care of. Not to say that somebody has commissioned a crime, kill them, do this. No, there is a format of how this person should be handled and of how the law is supposed to be like. The principle of legality takes about 4 steps or 4 elements. There are about 4 elements that guide the principle of legality, and let us enter into them. The first element is the pre-existence. That for someone to be convicted of any case, that case should have existed. It should have existed in the first place. The crime commissioned should have existed. That nobody should be punished on a crime which at the time of commissioning it did not constitute a crime. It was not there. So nobody can be punished because of that. Let's look at Article 28:12, where they say that for only there is an exception of contempt of court. Other than that, nobody shall be punished. Nobody shall be punished on a crime which at the time of commissioning it did not exist. It was not there. It is not allowed. So you can only be convicted or you can only be punished on a crime you have done and it is clearly described in the law. It is there, it is clearly described. So we are saying pre-existence of the law, Article 28:12 of the Constitution explains it. You can even go further and use Article 2:2 of the Constitution, that if you want to punish somebody on a crime which did not exist, you are violating Article 2:2 of the Constitution, that any law or custom that is inconsistent with the provisions of the Constitution, to the extent of it's inconsistent, that law is null and void. So it should be clear to everybody that you can only be punished on the crime that existed at the time you commissioned it. Let's take a clear example. The people who were homosexuals before this law was passed or enacted. So you cannot punish them at a time if they were there and they're homosexuals, because at the time 20 years ago when that was happening, there was no law governing them. There was no law. There was no clear law. The law was not described in the Constitution. So there's no way you would punish them. But we shall look at it more when we reach on the principle of non-retrospective aspect of the law. But let's go to the law must be clear. The second point, the law must be clear. That while handling these criminals or interpreting the law is ought to be clear to everybody. The law must be understandable. That is what the principle of legality says. The law must be clear. Let's look at the case of Andrew Mwenda and another versus Attorney General. In this case, the Mwendas were being castigated for seditious intention and seditious offense. That is in section 39 and 41B and 39(1)(a) of the Penal Code, seditious offense and seditious intention. In this case, the judges were very clear that punishing Andrew Mwenda would be violating Article 29, freedom of speech, or freedom of expression, and also would be violating Article 43 of the Constitution. So they are saying that it is not clear what amounts to seditious intention and seditious offenses. When you say that you have encroached on the peace of the president, don't you think it is going to cause a lot of havoc? Whoever comes and talks about anything, then those persons will be imprisoned. But remember, everybody has a right in Article 29 of speech expression. So what the judges did, they said these seditious intention and seditious offenses are not clear. They are in total violation of Article 29, Article 44 and 43 of the Constitution. And therefore, Section 39(1)(a) and Section 41B of the Penal Code were scrapped off. Just that they have not been yet changed, but they were declared unconstitutional. Why were they declared unconstitutional? They were not clear. They were not clear. Yet the law ought to be clear and understandable to everybody. So that is the principle of legality. It is saying that these laws that we follow, they ought to be clear and understandable to everybody. Let's go to the third point, that there must be limit on interpretation of the law, that the law must be interpreted clearly, that everyone must look at the law and understand it. It is clear, interpreted, that even if you arrest somebody, you must interpret to them. Look at Article 23(3) of the Constitution that says the arrested person immediately should be interpreted the type of offense they have committed and given space to talk to their lawyer. It is clear terms. Interpret the law. Let it be clear and understood. Let's take the case of Salvatore Aboki and another versus Attorney General. In the case of Aboki, the courts asked what amounts to witchcraft. They were being castigated for performing witchcraft. And the courts were asking, what is witchcraft? I'll put the question to you, whoever is watching this. If I have a spear, if I have a backcloth, if I have beads in my house, what does it mean? Does it mean that I am a witch doctor? Does it mean I perform witchcraft? So, the law should be interpreted clearly. Because of that, Section 3 of the Witchcraft Act was declared unconstitutional because it was not clear on what amounts to witchcraft. Tell us what amounts to witchcraft. So because it was not clear, Section 3 of the Witchcraft Act was scrapped off. So on limit on interpretation of the law, we shall use Article 23(3) and then the case of Salvatore Aboki and another versus Attorney General. Let's go on the third principle in the principle of legality. Sorry, the last principle. And this is the non-retrospective application of the law. That the law does not operate in a backward mode. The law doesn't operate going backward. The law operates moving forward. That is why even Parliament, in Article 92 part of the Constitution, Parliament is stopped from making laws that would interfere with the judgments of court, that would be taking us backward. I'll give an example. That now that we have a law on homosexuality, it doesn't mean that because the law was passed last year, it doesn't mean that we now go and look for everybody who had commissioned that and we arrest them. No. The law operates in a forward movement. In a forward movement, not in a backward movement. You can address yourself to Article 28(7) of the Constitution. So that, in a nutshell, is what we call the principle of legality. That we have said, the first one is pre-existence of the law, that the crime must have existed at the time when you commissioned it. The law must be clear and easily understandable. And then we are saying the limit on interpretation of the law and the non-retrospective application of the law. So we thank you so much for staying with us, and we ask you to subscribe and share and like our videos. Thank you so much.